So trademark has resulted in the 2009 hotly litigated lawsuit that ultimately Fender was wildly unsuccessful at protecting themselves.
Yes, and one federal court litigation that I'm aware of.
Fast forward from 2009 until this year, basically, they've come up with a new CEO who apparently, I'm assuming that the new CEO is the one who's pushing this. Mm-hmm. I don't know that for a fact, but that's the speculation that you see from most of the commenters that are out there. Now we're into the realm of copyright, where we're dealing with a different set of legal standards and considerations. Mm-hmm. They've at least got this default judgment, and that's under European law as
Yes.
opposed to US law. What does copyright look in terms of protecting the body shape under US law?
Yes. So yeah, in the EU, they have something called applied art designs, I think is what they call it, which is slightly different than what we have here in the United States, which is the trade dress. And then also copyright would be a potential means of protection. But copyright law in the United States protects works of expression. So when you have a utilitarian article, right, like a guitar, the question is, what, if anything, can be protected as an expressive element of this otherwise utilitarian article? And the law, and this is a fairly recently Supreme Court case where the Supreme Court reiterated the standard in trying to determine what, if anything, is protectable as copyrightable expression in a useful article or utilitarian design. And the rule is that whatever element is you're trying to protect under copyright has to be separable from the useful article. So a lamp is a lamp. It's useful. It's a utilitarian article. But if the base of the lamp is a very particular sculptural design, well, you can separate that sculptural element from the lamp. The sculptural element can be protected under copyright. I'm looking at this, maybe you can help me out, but it's hard for me to see, particularly given the fact that you have pointed out some functional reasons why this particular double cutaway design exists in it. It's hard to see, what would be separated out. Similarly, in the US, there's something called a design patent, where, because it's a patent, it has a limited term that's shorter than a utility patent. But in any event, you can protect an article of manufacture, a useful design. You can protect the ornamental aspects of it. But again, you have to articulate what those ornamental aspects are. So potentially design patent, potentially copyright, but that's the argument, and that's what Fender would have to show.
I suppose in particular, the pickguard section, you can have an artistic design of the pickguard section that would be copyrightable.
Yep.
But a pickguard itself would be functional.
Yeah.
And then we're still into like pickup selectors. That seems purely utilitarian.
Yeah.
Volume and tone controls, the pickups, the number and style of pickups. These are single coil pickups.
Yeah.
There's other style of pickups that function differently in terms of how they process electricity.
And you can understand why, right? Think about it. I mean, you can't give an exclusive term of use to volume buttons, right? If you are a maker of electric guitars, you're going to have to use volume buttons. So there are certain things you can provide exclusive rights to for a period of time under copyright or patent, but there's some things that you just can't remove from the public domain because of their intrinsically functional or utilitarian role.